The kids want their dad to come back home as well. He missed his daughter's eye surgery that she had yesterday on both eyes. Spring concert coming up next week on the 20th that he needs to be there for.
15 days in jail could jeopardize my job and my place of living. It really could. For missing work for my daughter's family will struggle. I'm the only one paying rent, Your Honor. There's no way I can avoid going to jail. I'm really going to lose my job, Your Honor.
State of Michigan versus Christopher Phillips, file 26-44356-FY, set for sentencing. All right, I do see Mr. Phillips. Mr. Brown is present as well. This is the date and time set for sentencing. Mr. Fortier, do we have a victim that needs to address me?
Your Honor, I believe that's Miss Raven, the one that spoke earlier as well.
All right. Ms. Raven, are you with us still?
Yes, I am, Your Honor.
All right. Is there anything that you would like to say in regard to this case?
Yes, Your Honor. I wanted to speak with you about lifting the try not to get emotional right now, to lift the no contact order with Christopher Phillips. He missed his daughter's eye surgery that she had yesterday on both eyes. He couldn't participate in that. His son has a spring concert coming up next week on the 20th that he needs to be there for. I've been struggling lately with him not being home. We had a dispute that shouldn't have turned out to what it should have been. I'm not afraid of Christopher. He doesn't scare me. He's not been like this in the last couple of years. We have our own place. We've been here for a year. We've been doing great. We got our family involved, and we shouldn't have. So I really wanted to lift the no contact order so he could come home. The kids want their dad to come back home as well, Your Honor.
Anything else that you want me to be aware of, ma'am?
He's a great guy, Your Honor. Like I said, he hasn't done this in a long time. It's been years. We've been together basically 7 years, and we have kids together, and we just want to be a family, Your Honor. And I would like him to come home if we could lift the no contact order.
Have you sought any sort of counseling?
Myself, no, I haven't, Your Honor. I am working on getting my insurance back in place. Because my insurance isn't active. I reapplied. I'm just waiting for that. I was going to seek that myself as a person anyway and get back on my medicine that I need. Other than that, I'm just waiting for the stuff to go through DHS for my insurance.
All right. The prosecutor's office has a very nice lady that works as what's called a victim advocate, and I'm sure that she could assist you in finding some counseling. There's also the Women's Resource Center, which I believe is free in many respects for counseling purposes for victims of crime. So I would suggest, I can't order you, I'm not going to order you, but I would strongly suggest that you take advantage of some of those things. I think it will help you to kind of understand the dynamics of how violence often occurs and what you can do to protect yourself, safety planning, all of those kinds of things. Hopefully this will never happen again, but it's always better to be prepared. It may also help you sort through some of the feelings that you have regarding the situation and whether or not you were placed in harm's way, whether your kids would be in harm's way, all of those sort of natural maternal instincts that I think might be helpful for you to talk about. And that also helps me to feel like there's a good reason to take off the no contact provision. I'm going to talk to Mr. Phillips about what he needs to do in just a minute, but I asked typically that both sides talk to a professional to get the best information that they can from that and then try to use it so that we don't have to have this be an ongoing pattern of behavior. And I think everybody doesn't want that. So thank you very much for your information today. I appreciate your comments. Mr. Fortier, any comments that you have, sir?
Judge, I would ask for a period of probation along with the Veterans Intervention Program, the men's group. So I believe that's a 9-month course. There's also restitution. The original amount was $1,791.18. I do have reports that Mr. Phillips has paid $250 of that, so the total has been brought down to $1,541.18. So I would ask that the court order that final amount as well. And then I will leave the issue of the no contact order up to the court.
Mr. Brown, allocution?
Your Honor, those are fairly standard probationary conditions. I'm not going to argue those. I imagine it wouldn't make a difference if I did. But as Raven said, Mr. Phillips is, I believe, the primary, if not the only support for the family. They do have children in common. They've been separated for quite some time. She said, even though he does have a history, it was several years ago, so this was out of his normal recent character. I would ask the court to take all of those things into consideration. I know the court's usual policy on the no contact order as well, but I would ask the court to especially consider Raven's position and her impact statement, Your Honor.
Thank you, Mr. Brown. Mr. Phillips, anything that you wish to say?
Yes, Your Honor. Excuse me. Yes, Your Honor. I don't disagree with anything that's been said. As Raven said and my lawyer said, Mr. Brown, I am the sole provider. I am the only one with transportation and a license for my kids. I know they've been missing appointments and everything due to me not being able to take them. I have completed men's group before. I do look back on that. I don't have any objection for taking men's group again. I have tried to get into counseling as well, but I got denied due to the fact that I'm not on the DHS case with Raven and the kids no more. And the denial letter stated that I am not at the address, so I would have to reapply for insurance as well.
All right, thank you, Mr. Phillips. Court would note, Mr. Phillips, as everybody has indicated kind of tangentially, Mr. Phillips does have a history. It is relatively old. There's an attempted aggravated stalking from the 57th Circuit Court, which is Emmett County, in July of 2016. There was a deferred domestic violence from the 87A District Court, this court, in March of 2016. So each of those are 10 years old. However, it's a repeat or very of the same or very similar types of behaviors, typically to those that we are most connected with, our girlfriends or significant others and those with whom we have children, which is likely to continue given the fact that we have that emotional connection with them and share children with them. So it's important that we do everything in our power to make sure that the counseling, the treatment, the education is done with every hope that it will connect. It appears that maybe the first time through the men's group, it did have some effect, because here we are, it took another 10 years before you got another conviction. Unfortunately, here we are again with another conviction. And I can't treat it as a first offense. I can't treat it as a one-off. You got the benefit of that last time when you got a deferred sentence on the domestic violence. So this is a repeat offense, and there has been time since the initial bad behavior, but it's here again, and I have to treat it that way. So I'm not going to treat it as a first offense. Mr. Brown alluded to my standard requirement for lifting of the no contact provision, and that is that both sides seek counseling. I'm not going to order Raven to do it. I've suggested that she will, and that's all I typically do. I think it would be good for her to do that, but I can order you to do that, and part of that would be going to the men's group. So I'm going to need to see a letter from your counselor that says that you have invested in counseling, that you are making significant progress in counseling, and that the counselor believes that there is nothing further that needs to be done, at least to the extent that you can go back with your significant other, with Raven. Obviously, the men's program is a long program. It's 9 months worth of that. I don't anticipate that you'd have to wait for 9 months to get it lifted. But I need to see some evidence on your part that you are serious about investing in the counseling, because that is, in my mind, the thing that's going to prevent this from ever happening again. So the no contact provision will remain in effect until a further court order, and that court order probably won't be given unless there's a letter or some testimony from your counselor that says he believes that that would be appropriate under the circumstances of this particular case. All right, so let's move our way through the sentencing process. I'm going to put you on probation for 9 months, mostly because the batterers or men's batterers program is a 9-month program. There's a $75 crime victim fee, a $50 mandatory justice assessment. There's restitution in the amount of $1,541.18, court costs of $300, a fine of $150, and a local charge of $15. 9 months will also cost you $270 out of a probation oversight fee. Let me add all of that up for you.
Judge, while you're adding that up, I just wanted to note that the restitution is payable to Patricia. I don't know how to say the last name, but it's D as in dog, E-U-R-S-E-N.
Durson?
That'd be my guess. I just didn't want to butcher it.
So you let me do it. All right. All right. Looks like the total fines and costs, including the restitution, is $2,251.18. That can be paid over probation. You may perform community service in lieu of some of those fines and costs at the discretion of the probation department. Must enroll in and successfully complete a treatment or educational program. That would be the men's batterers program. While you're on probation, there's no consumption or possession of alcohol or drugs, no entrance into a business where alcohol is served by the glass, and alcohol testing at the discretion of the probation department. May not associate with the victim in this case until the requirements that I put on the record have been met. Will be no assaultive, intimidating, or threatening behavior. And because of the prior convictions, I am going to impose 15 days in jail, 15 days forthwith. Once you're released from the jail, there'll be 5 days work camp to be scheduled by the probation department.
Your Honor,
Yes.
15 days in jail could jeopardize my job and my place of living. It really could. I'm already
understand
on
that.
probation at work for missing work for my daughter's stuff that's going on, and I can't miss work, Your Honor. I really can't. I have to work today. I will lose my job. My family will struggle. I'm the only one paying rent, Your Honor.
Mr. Phillips, this is the third time that you've been in front of a judge for violent or for similar types of or stalking type behaviors. If this were your first offense, I would be listening to what you're telling me. But this is not your first offense. You're going to go to jail for 15 days because that's what's necessary to get your attention. I'm sorry that it's going to have some consequences that you don't like, but that is the cost of doing business, of being violent in America, especially here in this county. There are other counties where you probably would go to jail for even longer. So I know that that's not something that you like. Nobody likes going to jail, but it's necessary so that you don't ever do this again. And that's all I can say for you now. You need to be at the jail today at no later than 6 p.m.
Okay, Your Honor.
Any questions, sir?
There's no way I can avoid going to jail. I'm really going to lose my job, Your Honor.
I'm really sorry to hear that. But no, there's no way to avoid that. Any questions, Mr. Brown?
Nothing further, Your Honor.
All right, that's all for today. Thank you. Good luck to you, Mr. Phillips.